Hi, everybody. Douglas V. Gibbs here, Mr. Constitution. Welcome to the video page, today's Daily Dose. And the United States Supreme Court recently made a ruling regarding guns and criminals. And I wanted to talk about this because a lot of people don't understand what's really truly constitutional, especially when it comes to Second Amendment and so on and so forth. Just for your sake, I'll read a little bit from the article so that you have this information. It says the Supreme Court split along unusual lines Thursday to rule in favor of a criminal defendant in a case that saw two of the most conservative justices form a bare majority with the court's three liberals. A 5-4 court decided with the defendant, who argued he should not be subject to the Armed Career Criminal Act, ACCA, 1984, a law that imposes a 15-year mandatory minimum sentence on certain repeat offenders who are caught illegally possessing a gun. Then it goes on to who decided this, who decided that, and Kavanaugh and Roberts, Alito, and Barrett were against it. Gorsuch and Clarence Thomas joined the more liberal, if you want to call them liberal, justices in this decision. And what's interesting, here's what Kavanaugh wrote. Today's decision overrides Congress's policy judgment. So first of all, they shouldn't be overriding Congress. That's beside the point. Congress's policy judgment about the risk posed by serial violent felons who unlawfully possess firearms. And today's decision will have significant real-world consequences. The case arose after prosecutors sought to apply the ACCA's sentencing guidelines to Borden after he pleaded guilty to illegally possessing a gun. The lower federal court and Cincinnati-based appeals court rejected Borden's argument for leniency, which prompted his ultimately successful appeal to the Supreme Court. So this is an interesting case. So let's now break it down. Constitution. Now, and understand, when I talk about the U.S. Constitution, I'm talking about the way things should be, not the way they always necessarily are. And sometimes don't misunderstand what should be constitutional just because it may ruffle your feathers a little bit doesn't mean it's necessarily a bad thing. We've been taught so much junk regarding the United States Constitution that sometimes it's hard to understand all of the details. So first of all, we go to the Second Amendment. Because since this is about guns, let's just go to the very basic foundation here. Second Amendment. And the Second Amendment, if you've ever read it, a well-regulated militia being necessary to the security of a free state, or the right to keep and bear arms shall not be infringed. The words, the shall not be infringed, first of all, are pretty definitive. Shall not be infringed. That means in any way. Then if you read the preamble to the Bill of Rights, and this is where sometimes I lose people, and so I want to make sure you stay with me here. Hang in there. I'll fully explain. All will be revealed by the end. If you read the preamble to the Bill of Rights, it says that the purpose of the Bill of Rights, those first 10 amendments, which includes the Second Amendment, is to prevent the misconstruction or abuse of its powers, the federal government's powers. And so further declaratory and restrictive clauses should be added. Purpose of the Bill of Rights was to make sure that the federal government did not misconstrue or abuse its powers. The Bill of Rights was written to the federal government, not to the states. I'm not saying the states can stomp all of your rights. Your rights are not determined by the Bill of Rights. Your rights are given to you by God. So whether or not it's listed in the Bill of Rights, a state constitution, or somewhere else, if it's a right, it's your right. If God gave it to you, it's your natural right. So don't get nervous just yet. But the Bill of Rights was originally written to only apply to the federal government. Even your most liberal historians will admit that. What happened after the war between the states is in the 14th Amendment, there's a clause that says, let me go to it real quick in the 14th Amendment so I can read what it says and then explain what's going on here. It says that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, what that is believed to have done, I disagree with this assessment, but what I just read from the 14th Amendment, Section 1, right after the Citizenship Clause, is believed to have done is to incorporate the Bill of Rights to the states. You can look that up. The incorporation of the Bill of Rights to the states is a doctrine that's believed that was put in place by that and then steadily put into more position through court decisions. That did not do that, I don't believe. If you read it, what it says is people shouldn't be denied their rights without due process. The states can't just deny your rights without giving you an opportunity to go to court over it and all that other jazz. And it was, of course, written to guard against the newly emancipated slaves as citizens of the United States being treated any different and having their rights treated any different than anybody else. It was an attempt to make sure that nobody's rights were infringed upon without due process and that nobody was treated differently under the law. Now, that said, shall not be infringed, definitive, and it applies to the federal government. As I told you, that means that every single federal gun law or any law involving guns of any kind by the federal government are unconstitutional. So, this ruling was actually a good ruling, technically. I doubt this was their reason. From what I read in the opinions, it wasn't, and this definitely wasn't the reason for the Democrats who ruled in this fashion. But the purpose of this ruling was really whether or not this person was could have be jailed or whatever for his third strike regarding the illegal possession of guns. His possession of a gun is none of the federal government's business. No law. I don't care if he's a criminal or not a criminal. I'm not saying I believe criminals should be running around with guns. I'm saying the federal government can't make that law. Shall not be infringed. That means in any way, shape, or form. That does not mean that the states have free reign on our rights or can just, take away our guns. I'm not saying that. The right to keep and bear arms still belongs to you, but not because of the Second Amendment. The Second Amendment is telling the federal government, hands off of your guns. So the court in this decision saying, hey, the criminal got in trouble for illegal possession of the guns. It should not be, go against him. Well, there should be no law regarding guns anyway, whether he's a criminal or not, because the federal government doesn't have that authority. It comes down to authority. Where does the authority lie? Well, the authorities lie with the states. In Federalist Paper number 43, which was written by James Madison, and I'll pull up that in just a second. He explains how the authorities are divvied up between the federal government and the states. James Madison wrote a number of the Federalist Papers. Alexander Hamilton wrote most of them, but a good portion of them was indeed written by Alexander Hamilton. Let me see here. Memo. And he says that the authorities, the powers given to the federal government are few and defined, and the ones given to the states are indefinite, numerous and indefinite. Then he lists, when it comes to the states and the federal government, what it is. For the federal government, it's the external things, such as war, trade, things like that. Things that normally would occur during wartime or dealing with other countries. And the state's authorities have to do with their internal order. And he lists in there, and it involves the life, liberty, and property of the residents or the citizens of the states. Those are your rights. So states have authority to make laws regarding your rights. Once again, don't get nervous. I know I live in California and they're all over our gun rights. And I hate saying what I'm saying, but they do have that authority, but they've gone too far. They are infringing on our right to keep and bear arms in ways that they shouldn't be. And unfortunately, the California state constitution doesn't have any language protecting the people from egregious, actions against our gun. There's no gun right. There's no gun language in the state constitution of California. But there are laws that sometimes need to be made regarding things like guns. For example, I'm very happy with the fact that my granddaughter, who's I think 8 or 9 now, I think she's 9 years old now, can't just go into the gun store, local gun store, and go purchase a firearm. There is a law in place that doesn't allow her to. But the federal government can't make that law. It's none of their business. But the state can. So it comes down to authority. The states can make laws like that. And the Founding Fathers did that because every state is its own different culture. So in some states, gun laws may be different in the case of necessity and things like that than other states. For example, in one state, it might be because of the population centers and stuff, they might want to make sure that the age is at 21. But let's say in someplace like Wyoming, it might be 14. I don't know. It might be okay to take your gun to school in certain cities, maybe not in others. That's up to the local government. I get it as a gun owner, as a gun enthusiast, as a gun rights advocate. I don't like the fact that there's any laws regarding our guns. But like I've said in past videos, government is necessary. Laws are necessary so we can properly, deal with each other, have an orderly society. It's like the intersection the example I like to use where, your right to go through that intersection stops at the next guy's bumper. So they put in a stoplight, not to stop you from enjoying your right of going through the intersection, but ensuring that you get through that intersection alive. And that your right to go through that intersection is not impeding the other person's right to go through the intersection. I have a right to swing my arms. I don't have a right to swing my arms into your nose because you have a right not to be punched in the nose. So I have to be responsible with my right. And there are going to be laws limiting my rights in certain ways, not because the government is fully, being tyrannical in that case, but because it's necessary for an orderly society. So the states were given the authority to make certain laws. So in this case, this legal case regarding this guy who the ACCA and a law on this criminal who's saying, hey, got caught illegally possessing a firearm, illegally possessing it based on whose standards? The federal government's. They're not supposed to have any standards regarding whether or not you have a firearm. Unconstitutional. Shall not be infringed means shall not be infringed. Every single federal gun law is unconstitutional. So the ruling was correct. Maybe not for the right reasons, but the ruling was correct. Ultimately, it goes back to the states. The states have the authorities over these things. Now, once again, I know some of you are uneasy because I'm saying, yeah, the states can make gun laws. And for those of us that live in states where they're really bad about it, that's kind of frustrating. That's kind of upsetting. But let me give you one more little factoid that I like to throw out there, an opinion regarding it that may help you understand where I'm coming from on that. There's a case, I don't remember what year it was, 2014, 2010, something like that. And it was McDonald v. Chicago. You may remember this case. Chicago had passed a law banning handguns. A guy named McDonald sued, worked its way all the way to the Supreme Court, United States Supreme Court. United States Supreme Court said that the city of Chicago could not ban handguns because of the Second Amendment. They were incorporating the Bill of Rights, the Second Amendment, to the state, to the city and the state. Well, if the language in the Second Amendment is going to be applied to the states, and then shall not be infringed means shall not be infringed, that would mean that every single state gun law would also be unconstitutional. That means we could have no gun laws anywhere if that was the case. But nonetheless, the Supreme Court ruled in McDonald v. Chicago that Chicago could not ban handguns because of the Second Amendment. And my phone blew up, man. My email blew up. Everything blew up. Doug, what a win for gun rights. And I said, don't be so sure. Think about what just happened. A federal court, the United States Supreme Court, just dictated to a city, and really to the state as well, what it can or can't do regarding your gun rights. Do you feel comfortable allowing the federal government to dictate to your local government what they can or can't do regarding your gun rights? The answer may have been right. They shouldn't be banning handguns. But do you really want the federal government dictating, telling your state and your cities what they're allowed to do regarding your gun rights? I don't want them doing that. That's a local issue. It's none of their business. It's none of the federal government's business. They're not supposed to be involved in it. My right to keep and bear arms is none of the federal government's business. If the state wants to have some laws, I don't mind, as long as the laws don't get ridiculous. If they get ridiculous, I'm not going to go running to the federal government to try to fix the problem. I don't want them involved. That means that we need to fix it. If the states are passing laws that we believe go against our right to keep and bear arms, then we need to do something about it. You put up or shut up. You fight to change the law back to something that's more in line with what our natural rights are, or you move to a state that has laws that agrees with what you think. That's what the founding fathers wanted. The states are allowed to be different, and the states are allowed to make laws regarding your rights, including your gun rights. But if they get ridiculous on it, it's not the federal government's job to get involved. We don't want the federal government involved. It's none of their business. And this is where we have fallen down on the job, because first of all, anytime anything happens with guns, everybody starts going, oh, well, Second Amendment, Second Amendment. No, it's a piece of paper telling the federal government hands off. Has nothing to do with your state laws. You don't like what the state's doing regarding your gun laws? Fix it. Or get involved with groups that are going to fix it. I hope this clarifies a few things, not only about this case, but about the Second Amendment and our rights. Remember, your rights are your possession. You don't have it because of the Constitution. You don't have constitutional rights. You don't have rights because the Constitution or the government says you have them. Your rights were given to you by God. You have God-given rights, natural rights. And they're your possession. Government's not supposed to do anything to interfere with them. However, once again, for an orderly society, laws can be made in some cases. But it's our job to make sure those laws are not egregious. But when it comes to the federal government, none of their business. Shall not be infringed means shall not be infringed. And like I said, I don't support the idea of the incorporation of the Bill of Rights of the states. I don't care how many judges says that's true. I'm looking at the Constitution, I'm looking at the original intent, and I'm looking at what the founders meant. And Chris Bingham was the gentleman who wrote, by the way, that clause of the 14th Amendment, and he did want it to be incorporated to the states. But when Congress approved that particular language to be a part of the 14th Amendment and it got sent out to the states, Congress did not approve of and did not vote in favor of the incorporation doctrine. That's why the court started doing it, because technically that language does not mean incorporate the Bill of Rights of the states. And because it doesn't mean that, that's why the courts began to do it regardless. And the problem is now we've got the courts legislating. They're changing what the law says, and they're not supposed to. There's nothing in the Constitution that gives them that authority. Nothing in the Constitution gives them the authority to modify a law, create law, or repeal law, strike down law. None of that. That's a legislative action, separation of powers. They can have a judicial opinion, and to this day, the dockets still begin. It is in the opinion of the court. They can have an opinion all they want, but to change a law or to strike down a law, that has to be up to the legislature. If the law is unconstitutional and the legislature doesn't strike it down or get rid of it, and the courts are saying, hey, they should be, then that's where the people are supposed to get involved and put the right people in so that the legislature does get rid of that unconstitutional law. Our problem is we have been complacent. We haven't been involved. All right, thanks for watching. United we stand, combined we kick butt. God bless America and God bless you. Be sure to subscribe to this video channel. This shows up on both YouTube and BitChute, and down the road someday I'll add other channels. Also, if you want to donate to the cause, DouglasVGibbs.com, politicalpistachio.com. There's donate buttons in each of those places. Really helps because the cost of doing what I do has been on the increase. I do have 7 books that I've written. If you want to check them out, go to DouglasVGibbs.com/books. I've got a couple more I'm working on right now. Until next time, be safe, be constitutional, and God bless.